All right, good evening, ladies and gentlemen of the media, and welcome to this emergency press briefing. In the last few minutes, many of you in the media have reached out to me seeking to inquire about what government makes of the press engagement that Her Ladyship, the Chief Justice, just had, which bordered on the petitions brought against her and the deliberations of the committee tasked to look into the matter. Ordinarily, if the matters were left to the content of the petition and the processes being undertaken by the committee, we will not have cause to comment, because those are matters beyond the purview of the president or the government. But a number of things were said at the media engagement that, if left uncorrected, could create an erroneous impression and project government in a very unfair, unjust, unwarranted light. To begin with, we respect the right of Her Ladyship, the Chief Justice, to express any view that she holds about the matter in question, to the extent that it is consistent with the rules, because the Constitution makes it clear what the processes are in determining a matter of the sort that we are engaged with. The Constitution requires confidentiality on the part of all parties. It is the reason why the Presidency, on behalf of His Excellency the President, has refrained from commentary on the matter beyond stating what the President has done in compliance with the Constitution. So it would have been desirable that that constitutional provision was respected by Her Ladyship the Chief Justice, so that we do not have to engage in public commentary up until the time that the committee looking into the matter makes their determination. We are compelled, however, to correct certain misimpressions that were created at the briefing. To begin with, let me point out that as yet, nobody has been able to ascribe any known verifiable constitutional breach to the President in the way that he has handled this particular matter. From the very first steps in this matter, the President has kept fidelity to the Constitution and has respected the spirit and letter of the Constitution. Everything he has done has been by the book. That is why all those who have commented on the matter, including Her Ladyship the Chief Justice, have been unable to point to any specific provision under Article 146 that the President has been in breach of. Second, in terms of confidentiality, the President has acted strictly in accordance with the Constitution. At no point in time has the Presidency put out anything in any way, shape, or form that remotely resembles any of the contents of the petition. And the only communication that has gone out on this matter have been about the steps that the President has taken in accordance with the 1992 Constitution, Article 146 to be precise. 3, Her Ladyship the Chief Justice all but insinuated that there was some political agenda at play to oust her, and that this whole process is a result of sin. Let me place on record, without fear of contradiction, and let me be clear that no such political agenda exists. His Excellency the President took an oath to which he was incidentally sworn by Her Ladyship the Chief Justice herself. And in that oath, he swore to abide by the 1992 Constitution. He is enjoined to act a particular way when he receives petitions of the sort that he has received. And that is all that His Excellency has done. He has had no choice in the matter. The president cannot say that he has a view about how things should be done, and therefore, if petitions have come, he will fail to act. If he did that, he himself would be in breach of the Constitution, and therefore, he has been enjoined to act as any responsible leader or president of the Republic of Ghana would be required to do, as stipulated by the 1992 Constitution. The fourth point is also that we cannot have a sacred cow mentality in the way that we handle state affairs. Every single public official, from the president to the speaker to the chief justice to Supreme Court judges to ministers to all public office holders, are bound by the provisions of Ghanaian law. Indeed, it was the former Australian Prime Minister, Kevin Rudd, who once said that when you join the game, you play by the rules. So no public official is allowed to raise him or herself above the laws of Ghana. It does not matter how sensitive your position is. Once Ghanaian law dictates that certain processes be undertaken in respect of some alleged misconduct, the rules must come to play. And that is the only guiding principle that President Mahama has operated by in all of this. So any claim, any inference, any innuendo, any imputation of a political motive to the president in respect of these processes are unfounded, they are false, and cannot be allowed to stand. And I wish to place that on record. As yet, absolutely no evidence of same has been furnished in any way, shape, or form. And therefore, I am minded to strongly reject that effort. Unfortunately, Her Ladyship, the Chief Justice herself, has added to this commentary, which initially was the tone of elements of the opposition. And it is deeply regrettable that this should happen when the president has been above board and conducted himself in strict compliance with the Constitution of Ghana. The other point that I wish to also place on record is that the attempts to link the dastardly killings of some Supreme Court judges and a military officer to this case are most disingenuous. To begin with, this government and President Mahama have nothing to do with the killing of any judge. Second, there's absolutely no nexus between the petitions that have been brought and that unfortunate incident in our past. So any effort to link the two is regrettable and should not find space in this sort of discourse. It is most undesirable, it is most unacceptable. Now, the venue in question is the Edu Lodge. Yes, it is close to the Osu Castle, which used to be the former seat of government. As I speak, there are government agencies that operate there. So it is a public place. The Osu Castle is a public place. You can go there to conduct official government business. Beside it are private residences owned by Ghanaians who move freely in and out of their residence, even though they are situated very close to the Osu Castle. So the impression that a facility in the vicinity of the Osu Castle necessarily makes it intimidating or foreboding is completely misplaced. It is unfair. It is not justifiable. Now, Edu Lodge is a state facility which is often used to house high-ranking officials who visit the Republic of Ghana. It belongs to the state. The decision to use that place was not that of government or President Mahama. The committee requested that they needed facilities of a certain status that could house their activities and that could facilitate a smooth running of the proceedings. And that facility was available. It is equipped with modern amenities that will facilitate the work of the committee. And the state only offered it upon the request of the committee. Let me also state that that facility is not intimidating. It is like any regular state facility where business can be conducted to the extent that it is put in the right shape. Wherever these proceedings were held, it will still be in camera, as clearly stipulated in Article 1468 of the 1992 Constitution. So that the proceedings are being held in camera is only in compliance with the Constitution. So it doesn't matter where it is held. And any security measure put in place is only intended to secure the place so that persons who are not authorized to be part of the proceedings do not come there and create any inconvenience. I believe that even if the hearings were held at the court premises, it will still be under significant security controls to ensure that only authorized persons have access to the place. So to describe Edu Lodge in the terms that her leadership, the Chief Justice, did, was most unfair and unjustifiable. It seeks to obscure the process and bring in unrelated matters that seek to cast some aspersion or ill motives on government for affording the committee a place to do its work. As I indicated, we have no interest in violating the Constitution by going into the merits of the case. And that is why government has refrained. Let me put it on record that government itself has had cause, indeed the president himself had cause, to lament the way in which some correspondence around this matter got into the media. You will recall that the very first sign of any leakage was the letter that the Chief Justice wrote requesting for copies of the petition. Before the letter got to the presidency, it was in the media. And you recall that in the president's response, in which he also took the opportunity to forward the petition to her, we raised that issue, that it was not acceptable. Indeed, we had cause, the president had cause then to ask his executive secretary to mark the documents that were being sent to the Chief Justice in order to guard against any leakage. So at no point has anybody leaked anything. Also, it must be noted that even the media houses that first broadcast the content of these petitions were media houses that you can say are aligned to the opposition. And they are the ones who have gone to town with this sort of thing. So to attempt to cast aspersions on the presidency is most unfortunate, and it causes what should be a smooth process leading to the determination of the merit or otherwise of the petitions that have been brought. So in summary, I would say that what has happened today is most regrettable. And as government, or as the president, President Mama is committed to upholding the rule of law. We cannot have a situation where, depending on who is involved, the Constitution is set aside. All Ghanaians are equal before the law, in the same way that our courts have dealt with individuals in accordance to law. If members of the judiciary themselves are alleged to be engaged in some wrongdoing, the processes laid down and spelled out by the Constitution ought to be respected. And that is exactly what has happened. I thank you very much. If there are any questions that you have, you may ask them.
So,
yes.
The embattled Chief Justice made reference to veiled threats on her life, and much as you're concerned about sticking to the sanctity of the constitutional procedure she needs to go through, you should equally be worried about this threat on her life. What's government's response to the specific issue about threats on her life?
The Chief Justice, more than anybody else, perhaps in this country, should be aware of the platform that is available to address such threats. Kamala, if today somebody sends you a threat, you know exactly where to go to seek redress in the matter. And that is what I would say about it. Yes, Akusia.
One of the groups that petitioned, the Shining Stars group, the Chief Justice in her press conference indicated that her research done by her team show no traces of authenticity when it comes to that particular group, that the group has not been registered. Can you authenticate that group if we know anything about the Shining Star?
First of all, I'm not sure whether there are provisions covering this, whether there's a requirement for authenticity, as it were. There were also individuals. How do you authenticate the individuals? What matters is that they have raised issues, and the Chief Justice was given opportunity by the President and the Council of State to provide initial responses, which then formed the basis of the determination of a prima facie. The President, in consultation with the Council of State, came to the conclusion that there was a basis to proceed further. The President then, in accordance with Article 1466, I believe, set up the committee as spelled out by the Constitution and gave them the petitions to look into. The processes have been ongoing for quite some time now. So as far as the President is concerned, every law, rule, or regulation or process that has to be adhered to has been respected. So I do not know how this particular matter in any way impinges on the integrity of the process that has gone on so far. But then again, the Chief Justice has had cause, at least on 5 occasions. The Chief Justice and others, I must indicate, have had cause at least on 5 occasions to go to the Supreme Court to seek redress in the matter. And on all occasions, the Supreme Court has upheld the process as is currently underway. And so that, for me, should resolve the issue beyond any reasonable doubt. Yes, Max.
Yeah. Okay, so my question is there any timeline that we're looking at for the committee to finish the work? Because in her speech, she made accusations that there's an attempt to frustrate her. There's also an attempt to intimidate her to get her to resign. And she made that point clearly and forcefully that she's not going to resign. I'm curious to know whether there's a specific timeline by which this hearing, should be done.
Max, as I've been at pains to explain all evening, the President can only proceed on the basis of law. The law spells out what can and cannot be done. The Constitution does not set a timeline, and therefore the President cannot impose a timeline. Indeed, at this moment, the matter is entirely out of the hands of the President, insofar as it is seized with the committee. The President cannot direct the committee on anything that they should or should not do. So it is only they who can determine the processes that are laid down to undertake this particular activity. And as and when they finish and make recommendations as stipulated by the 1992 Constitution, the President is bound to act in the manner that they recommend. So I am not in a position to speak to any timeline, neither is the President. It is only the committee that can determine when sufficient time has been had to look into the matter. Yes. Is there any? Yes.
Are there any specific reasons why the hearing has not been done in camera? Because we know the Constitution says it clearly in 146.
Well, your question is self-explanatory. You've answered it. The Constitution says it should be done in camera, which means it should be done in secret.
Yeah.
Yes. So it has been done in secret, not so.
Yeah.
So why can there be a complaint about what the Constitution? First of all, there are 2 things that we must distinguish from each other. You can disagree with the constitutional provision. There are many in this our country who have criticized the use of contempt by courts to punish people who they perceive run extrajudicial commentary on cases that are pending. There are many people who have disagreed with it. Indeed, I have on occasion expressed my disagreement. But that is the law. Until the law is changed, you cannot say that you disagree and so it should not be applied. Same applies to this particular process. So whatever view you may have of it cannot stop the law from working. And that must be clearly understood. So we must separate criticism or misgivings about the law as it stands from adhering to the law. And as yet, nobody has been able to say that this particular law under Article 146 has been violated by the President. And that is a point that must be stressed to the hearing of all. So, if the law says that this process must be held in camera. The president has no choice than to act in ways that respect this. And I believe the committee is also respecting it at this. Indeed, the Constitution does not allow for commentary on the substance of the allegations. And there are those who may criticize the Chief Justice for violating same. We have not done that. And as I have indicated, I am not prepared to speak to the content of the petitions because we are not allowed to do so. And the president has acted in ways that the Constitution stipulates. So there cannot be a problem with this. That is why all those who have spoken have not been able to point to one evidence of infraction by the president in all of the things that have happened thus far.
Finally, we are getting this news that the Chief Justice and the legal team has filed a judicial review at the High Court.
She is entitled to do so, and we encourage her to avail herself of any opportunity there is to vindicate her rights. Yes.
Honorable, the suspended Chief Justice in her press briefing mentioned that she has received some call from individuals asking her to resign willingly or voluntarily to save her image. Has any government official or you yourself in any way called her to resign willingly to save her image?
Why would I do so? That will be the basis for me to place such a call. I have not. I have never spoken to the Chief Justice in my life. Second, no government official has placed such a call. If individuals in their private capacities, in their private lives, believe that they have a relationship with her and want to call on her to act one or the other, it is a personal decision that she would have to take. But government or the president cannot force her or even suggest remotely that she should resign. So that must be placed on record. To be fair to her, I don't think that she said that any government official has asked her to do so. So we must also correct the records as they stand. Yes.
Wow.
Yes.
The first time the Chief Justice leaked her own response before getting to the president. The second time, she chose to hold the presser and level serious allegations against the government. Do you suspect that the Chief Justice has an ulterior motive to paint this government black?
Well, I cannot ascribe any motive to the Chief Justice except to express regrets over an act that may appear to violate the Constitution. But I don't think it would be fair to ascribe any motive. As I said, she has every right to adopt any measure she believes will aid her make her case, except that we all know that it is better to do so using laid down processes. Beyond that, I don't think that anybody can ascribe any ill motives to her. We have a responsibility to correct any misimpression created about how the president has acted. That is the responsibility that I am discharging today. That is all that there is today. Indeed, if there had been no references to murdered judges and the venue, which is a state facility, or some political vendetta or agenda, I will not be addressing you. If it had been purely based on sentiments about the outcome of some court cases, or even the process that the committee is using, we would have no locus to wade into the matter. If the committee is minded and they have a way to engage the public, so be it. But I have only addressed you for the sole purpose of correcting what is a false impression that there's some political agenda at play, or that the venue has been chosen for purposes of intimidation and as a way of using some dastardly occurrence in the past as a psychological tool to wear anybody down. That is what we decry. We don't think that it has any place in this discourse. It is most unfair, most unjustified, most unwarranted. And that is the reason why I have been compelled to speak to you to clarify that matter. Thank you all for coming.